Committee will come to order. First of all, I want to begin by thanking all the witnesses for their patience. We've had a possibly historic number of votes today consecutively. We've been voting pretty much for the better part of 8.5 hours. And so when there's a vote on in the House, it takes precedence over committee meetings. And as important as this committee meeting is, we wanted to come back here to continue and not to ask you to try to make arrangements when many of you have already traveled a great distance. I've talked to many members since every member has had a great deal of difficulty in their own schedules. We'll have some members who will be coming in and out, but in the interest of proceeding efficiently and getting to the witness, I'm going to ask those members who are here to limit their opening remarks, if they have any, to 2.5 minutes. So without objection, opening remarks will be limited to 2.5 minutes. Without objection, we'll be joined by Senator Sanders. Welcome, Senator.
Thank you.
This is the Domestic Policy Subcommittee of Oversight and Government Reform. I'm Dennis Kucinich, Chairman of the committee. The title of today's committee is After Injury, the Battle Begins, Evaluating Workers' Compensation for Civilian Contractors in War Zones. This hearing, After Injury, the Battle Begins, Evaluating Workers' Compensation for Civilian Contractors in War Zones, will evaluate workers' compensation insurance for federal contractors working overseas under the Defense Base Act, a little-known law passed in 1941 requiring all U.S. government contractors and subcontractors to secure workers' compensation insurance for their employees. Today's hearing focuses on why the men and women who support our troops in Iraq and Afghanistan, many of whom are former members of the military who re-entered the war zone based on a sense of patriotic duty or economic necessity, are coming home only to battle insurers which deny them the medical care and benefits that American taxpayers have paid for, and why the same system richly rewards the insurance carriers for doing so. Over 35,000 contractors have been killed or seriously wounded in Iraq and Afghanistan since 2002. In this subcommittee's investigation, we have heard story after story of injured workers coming home minus a limb or traumatized by war zone experiences seared into their psyche, only to face the fight of their lives with their company's insurance carrier. AIG's record is of particular concern given the enormous federal subsidies it receives. It is already well known that AIG awarded hundreds of millions in bonuses to top executives who have led the company over the abyss. What this hearing will establish is that the same company has refused to pay the prescribed benefits to an injured contractor without first putting them through a protracted fight. CNA, which is a much smaller player in the Department of Defense DBA market, nevertheless distinguishes itself for the lengths to which it will go to deny injured contractors' benefits and deny the existence of the phenomenon. This hearing will also demand to know where the Department of Labor has been since the start of the war to ensure injured workers are obtaining the benefits they deserve. The Department of Labor's Office of Workers' Compensation Programs, which oversees the program, is drastically underfunded and understaffed, and its ability to oversee this exploding program has suffered as a result. But it is also clear that under the previous administration, the Department of Labor took a hands-off approach to overseeing the DBA program. We're going to look forward to hearing from Deputy Secretary of Labor Harris on how the Department of Labor intends to increase its oversight role and help improve the delivery of benefits to injured workers. I hope this hearing will serve as an impetus for the reform of the Defense Base Act. And now I'm going to welcome and yield to our ranking member, and I'd just like to say thank you for being here. Before you arrived, Mr. Jordan, we did unanimous consent that all members would have 2.5 minutes, including us, in order to get to the witness, sure, and that we welcomed without objection and a unanimous consent for for Senator Sanders, sure, to join us. So we will go to you for 2.5 minutes. The ranking member, Mr. Jordan from Ohio.
Thank you, Mr. Chairman. And I have a short statement. I'll read fast. Thank you, Chairman Kucinich, for holding this hearing. I would like to especially thank the contractors who are here with us today for their service to our country, and I look forward to their testimony. As the battlefield has evolved, contractors are indispensable. Without contractors in Iraq and Afghanistan, our troops would not have the food, shelter, supplies, or technology necessary to complete their 21st century missions. Defense Base Act, or DBA insurance, is statutorily mandated for contractors working on U.S. government contracts overseas. In recent years, we have seen cost increase as claims have increased. In a program as vast as DBA, there are going to be failings. We need to do everything we can to correct those failings. I hope this hearing will provide us an opportunity to survey the DBA program as a whole. It would be preferable to bring all parties, the Department of Labor, the employees, the contractors, and the 5 insurance providers to the table to discuss where reforms are needed. Today, however, we will hear from only 2 of the 5 providers and none of the employers. It's Congress's job to ensure the DOL has the resources and statutory authority to educate contractors about DBA, facilitate information sharing between the contractors and the insurance companies, answer questions of statutory interpretation, adjudicate disputes in a timely manner, and oversee employee rehabilitation programs. I look forward to hearing what initiatives DOL has in place to make the DBA program more efficient. Finally, I'd like to express my disappointment that the investigation leading up to this hearing has not been completed in a bipartisan manner. The Republicans on this committee were not included in any of the preparations or deliberations leading up to this hearing. Consequently, as we sit here today, we are not as well positioned to educate our members about this topic and not in a position to pass judgment on either the legitimacy of the contractor's claims or the propriety of the insurance provider's decisions. I hope we can work more closely together in the future. Again, thank you, Mr. Chairman, and I look forward to the testimony.
I thank the gentleman. The Chair recognizes Mr. Cummings for 2.5 minutes.
Thank you very much, Mr. Chairman. Thank you for holding this critically important hearing to examine workers' compensation for civilian contractors in war zones. I requested this hearing following the April 17 publication of an extremely troubling report by the Los Angeles Times in conjunction with ABC News and ProPublica that the health insurance claims of civilian contractors who participated in military operations in Iraq and Afghanistan are being consistently denied. As you know, Mr. Chairman, civilian contractors, many of whom are veterans themselves, are serving an increasingly important role in achieving our mission in Iraq and Afghanistan. These brave men and women were alongside our uniformed service members, consistently displaying acts of heroism on behalf of the American people. Tragically, recent news reports indicate that our commitment to them does not parallel our commitment to their country. Just as there was public outrage over substandard conditions at the Walter Reed Medical Center, so too should we be appalled by the stories we hear today from civilian contractors who were injured on the battlefield and then abandoned here at home. As you know, Mr. Chairman, the Defense Base Act, the DBA, requires contractors and subcontractors to purchase workers' compensation insurance for employees working overseas. The insurance purchase must cover medical care and disability payments for workers injured in the performance of job duties. It must also provide health death benefits for the families of employees killed on the job. The costs of insurance premiums paid by the contracting firms are then built into the price of the contract between the contractor and the federal government. Right now, there are more than 31,000 current and continuing civilian injury claims, as well as more than 1,400 claims for death benefits. The American International Group, AIG, and other insurers have received some $1.5 billion in premium payments while paying out $900 million in compensation and expenses. What a deal. According to the April 17th article, AIG is a primary insurer retained by contracting firms handling some 90% of civilian claims filed in war zones in 2007. And I could go on, but because of time, Mr. Chairman, I will submit my entire statement for the record.
The gentleman, without objection, the gentleman's statement will be submitted to the record, and I'll submit my entire statement for the record as well. The Chair recognizes Senator Sanders from Vermont.
Thank you very much.
2.5 minutes.
Thank you very much, Chairman Kucinich, and Ranking Member Jordan. Thank you very much for the opportunity to say a few words. What we're looking at is an horrendous situation in two regards. Most importantly, men and women who have put their lives on the line in Iraq and Afghanistan, civilians working for private contractors who have been wounded, came home with the expectation that they would get the care and the benefits that they were entitled to. And what we're seeing is time and time again, large insurance companies like AIG are denying them the benefits that we have paid for as taxpayers. That's issue number one. Issue number two is that at a time when this country has record-breaking deficits and an $11 trillion national debt, it is our obligation to make sure that taxpayers' money is well spent. And I think any serious investigation of how money for workers' compensation in terms of these private defense contractors has been spent will indicate that there has been huge wartime profiteering. And that is an abuse of taxpayers' money that is not acceptable. Clearly, under the last administration, there was virtually no oversight in terms of the Department of Defense and the Department of Labor. So I think the time is long overdue for us to take a very hard look at the Defense Base Act, make sure that all of those men and women who are hurting today get the care that they need, and we've got to make sure that we are not continuing to waste billions of dollars of taxpayer money. Thank you, Mr. Chairman.
Thank you very much, Senator Sanders. We're now going to go to our witness. Since there are no further comments from members, I want to start by introducing the first panel. Seth Harris was sworn in as Deputy Secretary of Labor on May 26, 2009. You have an extensive background, which we'll submit for the record, but in the interest of expediting this hearing, we're going to go to your testimony. It is a policy, Mr. Harris, of the Committee on Government Oversight and Reform to swear in all witnesses before they testify. I ask that you would please rise and that you would raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Let the record reflect that the witness answered in the affirmative. Mr. Harris, we're going to ask you to, all witnesses were invited to give a five-minute statement. I think that's a good idea that we try to stick to that. So would you proceed with a 5-minute statement? In any event, your entire statement will be included in the record. We'd like to hear from you, and then we're going to immediately go to questions of you from the members, and then after that we'll go to the next panel. Thank you very much.
Thank you, Mr. Chairman. Thank you, Congressman Jordan, Senator Sanders, and the other members of the subcommittee, Congressman Cummings. As the chairman said, my name is Seth Harris.
Excuse me, sir. Will you pull that mic a little bit
I'm
closer,
sorry.
because there's a pretty high reverb in this room.
I'm the Deputy Secretary of Labor, and as the Labor Department's Chief Operating Officer, I oversee the Office of Workers' Compensation Programs Administration of the Defense Base Act. I'm grateful for this opportunity to discuss the Department's role and responsibilities under the DBA and the values we bring to the discussion of how we might reform this important program. Let me begin by thanking Chairman Kucinich, the other members of the Domestic Policy Subcommittee who played a leadership role on this issue, and Senator Sanders. You've raised important issues about the operation of the DBA program and put the program on the path toward reform. Through your efforts and the diligent work of your staff, the issues are being explored and the program's problems are being brought to light. The Defense Base Act needs significant reform. The Department of Labor looks forward to working with you and other agencies of government to diagnose honestly the problems in the program and to craft the right solutions to those problems. I'd also like to take a moment to recognize and express my respect for the civilian contractors who will address you this evening and in the process represent thousands of others who were injured or killed while giving support to our armed services and civilian agencies. The workers' compensation program they relied on to care for them in their time of greatest need did not work as well as it should have, and they deserved better. Now we must build a better system for them and for future claimants. Mr. Chairman, the Department's goal is to reduce the consequences of work-related injuries. Civilian contractors who work overseas in support of our military and civilian agencies should receive prompt and appropriate benefits to remedy the physical, psychological, and financial effects of injuries that happen in the course of their employment. Employees should know what benefits they may be entitled to and how to get them. Employers and their insurance carriers should have systems in place to respond to injury claims and voluntarily provide necessary medical benefits and monetary compensation for disability or death as quickly as possible. I look forward to working with you to build a Defense Base Act system that serves those values better than the system we have today. The Department of Labor recognizes that the DBA, under the extreme and evolving conditions in which it's now applied, is insufficient to meet the needs of its major participants. Written in 1941, the DBA was designed to protect a small cadre of American workers primarily engaged in engineering and construction work in Europe and the Pacific. Now, the program serves an enormous international workforce engaged in nearly every imaginable type of occupation. They're employed by both American and foreign companies, large and small. There are multiple layers of subcontracting, and to further complicate matters, contractors serve in distant countries with major language, cultural, and infrastructure challenges. In many cases, they serve in war zones and face the persistent threat of grievous injury from new types of insidious attacks, sometimes with limited medical care availability and the added challenges of evacuation. The Department of Labor knows about these difficulties, but we are trying to meet a complex 21st century challenge with a program from World War II. It simply isn't up to the task, and fundamental reform is needed. The Department has made every effort to implement the DBA fairly and effectively. However, it is my sense that even with additional resources, more modern technology, and redoubled effort by all concerned, the Department's effort would be insufficient to overcome the systemic challenges now facing the DBA. And we've already begun evaluating alternative approaches with the contracting agencies. The present structure of the DBA insurance program is characterized by severely limited competition in the insurance market, varying premium rates, procurement of insurance through widely divergent processes, and significant limitations on the ability to track and account for the contractors, subcontractors, and contract workers involved. These systemic problems raise serious questions about a whole range of issues, and I've got a long list of questions, Mr. Chairman, which we can come back to if you'd like in questioning, but I don't want to go over my time. The list of problems with the existing DBA program, along with others that are not on my list, is extensive and troublesome. However, the list of options to address these issues provides various paths to change and, we believe, improvement in the DBA program. We see four basic options with flexibilities within each. First, Congress could decide to leave the basic structure as is, but revise specific sections of the laws to clarify, strengthen, and reform identified weaknesses and define what is not clear. Second, Congress may decide to replace the existing system with an option for the contracting agencies to self-insure their contracts instead of procuring private insurance, or to remain in the private insurance system that currently exists. Third, Congress may decide that the entire federal program should be self-insured under one entity with no option for private insurance. And fourth, Congress may decide to simply leave the DBA statute as is, but provide additional resources to strengthen the oversight, regulation, enforcement, and reporting processes. The most important step the Labor Department can now take is to work closely with this subcommittee and the contracting agencies to analyze these options and determine which will best serve the civilian contractor workforce, and we're committed to taking that step. Mr. Chairman, I look forward to your questions and those of the members of the panel.
I thank the gentleman. We're going to now move to questions from members. I would just ask the witness and all other witnesses who would come in other panels that when you're asked questions by members, please answer the question directly and be as succinct as you can in the interest of trying to get as much of the information that you have available to members of this committee. I'd like to begin by talking about the Office of Workers' Compensation. I understand this office has been underfunded for the past 8 years, but does the Department of Labor really maintain records showing insurance coverage with such advanced technology as this 3x5 card? It says here this form was last updated in 1976. Is this the way you keep records there?
Yes, Mr. Chairman, and you're right that that card dates from the Ford administration.
Is it time to upgrade the system?
It is time to upgrade that system, and we are going to fix that. We have a plan that we're ready to implement, and we're going to fix that system. That is the card on which we receive information from the insurers about who they have covered, and we have a long stack of those cards, and that we use to get this
information. Would you agree that if you have a lot of claims, wouldn't it be important to the claimants to be able to have their data entered into a reliable and sophisticated data collection system?
I think that is right, but let me say that card isn't for claimant data. That card is for
the employers and the address.
Insurers, right, insurers' coverage of employers. That's right.
Okay. Well, so you're saying, you're committing that you're going to work to update it.
We're going to fix it. Absolutely, yes.
Now, I want to ask you also, your staff has made some disconcerting statements about the Department of Labor's authority to enforce DBA requirements. One staff member referred to the Department of Labor in these terms, said that you're at best a scorekeeper, not really a referee. We know the difference between a scorekeeper and a referee. Another staffer said that Congress intended the DBA program to be self-executing, where a DOL only sits back and watches and jumps in when something goes bad. Do these comments represent accurately the current administration's view about its responsibility for DBA workers' compensation insurance?
No.
Will you change DOL's policy and culture so that the Department of Labor exercises more authority?
Well, the statute defines the scope of our authority, and the descriptions that you just repeated from members of my staff, and I'd be curious to know who they are, by the way, I don't think accurately capture what our statutory role is. We are our
But you do have, I mean, the Department of Labor has a poor record of overseeing DBA insurance. That's a legacy you do not want to repeat, I take it.
Well, I don't want us to do a poor job. That's certainly true, Mr. Chairman.
Are you going to ensure this subcommittee that you're going to conduct a top-to-bottom review of the Department of Labor's role in administering the DBA insurance?
Well, I think the most productive thing we can do, Mr. Chairman, is to work with you to fundamentally change the program. I think that there are a lot of administrative reforms we could make, and we should do those. But let me say, the program is not designed for the circumstances that we're in right now, and what we need is fundamental reform. I think more resources, better technology, better systems might improve the circumstances somewhat. But let me say, for the folks who are going to be testifying on your next panel, I'm not sure any of those processes would have changed the outcome in their particular cases. It's the system that we have, that, you know, a system that depends upon private insurance, that is an adversarial system like many workers' compensation systems, unfortunately, and a system that results too often in adjudication that takes months and months and months and months.
But it is true. It is true. If you're working with old technology, that can slow down claims. And if you have insurance companies that don't want to pay the claims and a technology that slows down the claims, you're going to have a frustration in the first case of people not getting their case in front quickly enough, and in the second case of just the insurers not wanting to pay. That's the concern that we have.
Well, I share the concern that the technological problems or the systems that we're currently using result in some delay, but let me say I don't think that's where the bulk of the delay in the system comes in. It's when you end up in an adversarial relationship between the insurer and the claimant.
Well, let me talk about that, if I may, because I have my time's running out to ask you questions. What are the limitations in the defense in the DBA that prevent the Department of Labor from playing an active watchdog role? The Act specifically states that the Department of Labor may, quote, provide persons covered by this Act with legal assistance in processing a claim. On DOL's website, it states, the Department of Labor administers the Defense-Based Act, ensuring that workers' compensation benefits are provided for covered employees promptly and correctly. Please, if you could respond briefly.
Yeah, the role of the Labor Department is to process these claims and to mediate, when there are disputes, to mediate disputes between the insurer and the claimant, and to cajole, to pressure, to beg, to beat about the head and neck the insurers who are denying claims, and to get to settlement as quickly as possible. We are not, however, an arbitrator, or a judge. There is an adjudicative process that follows, and when the Office of Workers' Compensation Programs advocates on behalf of a claimant and the insurer still refuses to pay, we end up with a referral into adjudication, and that's where I think the delays come in.
I thank the gentleman. I thank the gentleman. The chair recognizes the minority leader, Mr. Jordan.
Thank you, Mr. Chairman. Mr. Harris, you've been, did I get that right in the chairman's intro? You've been on the job 3 weeks?
I'm sorry, I'm having trouble hearing you.
Did I get that right when the chairman introduced you, that you've been on the job 3 weeks?
It seems a lot longer, but
Yeah,
yes,
okay.
it's been about 3 weeks.
Well, Mr. Chairman, some of the line of your questioning, I think, was right on target. This is the second hearing I think we've had in 6 weeks, which dealt with a program at the Department of Labor where we've, nothing against Mr. Harris, but, you know, he's been on the job 3 weeks. I think 6 weeks ago when we had the hearing on the H-2B program, we had no one from the Department of Labor here to talk about what was going on there and the lack of oversight that they had there. You know, this is serious. Mr. Harris, in your testimony, you talked about I think you said 4 approaches that would help improve this entire operation, and I just jotted them down because I didn't have your testimony right directly in front of me. You said one was to kind of define, clarify, refine how the current system works. I think the other one you said was to allow employers to self-insure. Third option was to have the entire system in some kind of self-insurance, and then the fourth one was more dollars. More resources, I think, was your term. Walk me through those real quickly. And which do you advocate? Which do you think makes the most sense? Give me your thoughts on that.
I thank you for that question. Let me just, if I could, modify your description of the second option a little bit. It would be the contracting agencies that would self-insure or have the option of self-insuring rather than employers. There is some self-insurance by employers here that are not insured.
Okay.
Each of these options serves different purposes and accomplishes different results. So the question is, what problems are we most interested in trying to solve? If the principal problem that we're trying to solve is that this is an insurance market that doesn't have enough participants, self-insurance might very well be a uniform self-insurance system might well be the way to go. Mm-hmm. But we need to engage with the contracting agencies. The Department of Defense is going to come forward with a report in July. We need to engage with them to try and winnow down these 4. But I think that what we're trying to suggest to the committee is that these are 4 options with variations within each of them that I think that the committee should be thinking about as it considers legislation.
But the question, I guess, is which one do you advocate?
We're not advocating for any of the 4 just yet. We need to engage the contracting agencies before we're prepared to do that.
And the study you said is going to be, the study is coming back when, next month?
My understanding is that the Defense Department is going to be reporting on July 13th about this program and about the scope of contracting. And
we'll look forward to that study. When the United States first went into Iraq and Afghanistan, many of the defense contractors, especially subcontractors, were unaware of the requirement to get the DBA insurance. What is the department doing now to make sure they are aware of that requirement?
We're working with the contracting agencies. Let me just say, the Defense Department, State Department, and USAID are right now working on trying to develop a comprehensive database of contractors. One of the problems that we've had is that we don't know who all the contractors, subcontractors, and sub-subcontractors are, and all of them are supposed to be insured. So we're working with them and trying to develop that database, but we're also working with them to try and get information out to the contractors and subcontractors. That is a very, very difficult task because often you have foreign subcontractors working for American contracting companies. It's just, frankly, that has been one of the biggest challenges. There are contractors in this system that are not insured.
But I assume there's some kind of formal education process that takes place on the front end. How does it work?
That's a fair question. I'm afraid I'm not going to be able to give you an answer to that. I don't know. I'll be able to get you more information about that, but I can't describe the way in which we educate contractors as they enter the system.
Okay.
But I'm happy to get you, my staff will get you some more information about that.
Let me do a related question then here I have. DynCorp created what they refer to as Civilian Police Employee Assistance Program, which informs employees about preparations they need to make prior to going to Iraq, Afghanistan. And then in the event of injury, SEEP officials act as an intermediary between the insurance company and the employee. Is this a good idea, this kind of approach? Do you think it's a good idea?
Where the employer provides an intermediary with the insurer. I don't know. I don't know how. I'm not familiar with that program, so I don't know how well it works. I think anything that gets insurers to respond more quickly and gets those benefits paid and the medical benefits, the compensation and the medical benefits paid more quickly is a good idea. But let me just say, I think that sort of tinkering around the edges is not going to work here. I think that we need to really look at fundamentally changing this program, because the system first, is certainly not geared for the number of contractors that we have right now. When this program was created, we were talking in the numbers of hundreds. Now we're talking in the thousands, 15,000, I believe, in the last fiscal year. That's a lot of claims for a system that's not built for that, to manage that quantity of claims. So individual programs here and there may benefit, but as I said before, I think we need to look at fundamental reform.
Thank you, Mr. Chairman. Thank you.
Thank you.
I thank the gentleman. The chair recognizes Mr. Cummings of Maryland.
Yes, Mr. Harris, let me ask you this. This is, you said there was limited competition? I mean, in other words, there were limited numbers of insurance companies doing this?
That's true. My understanding is that the three large insurance companies have about 90% of this market, AIG, CNA, and ACE. And I believe that AIG has 80% of the defense market. That's not very much competition. And I believe the State Department has a sole source relationship with CNA. I may be
okay. All right. Let me tell you where I'm going. Let me guide you to where I want you to go.
Sure.
They can't lose with this, can they? With these contracts, they cannot lose. As I understand it, the way this DBA is structured, they cannot lose. In other words, the insurance company can't lose. Am I right?
That because they're going to get paid the premiums.
They're going to get paid big time. Hello? Am I right?
I think that's right.
Then why is there limited competition? I don't understand it. We've got a profit. I mean, folks, corporations usually operate based on profit. You're telling me there are three companies, they cannot lose. So why is there limits?
Yeah,
I'm not knocking you. I'm just curious.
Yeah, I think that's an excellent question, and I'm not sure I'm the right person to answer it. I would say we were actually talking about this earlier today in preparation for the hearing. I think one part of it is that the barriers to entry into the market are pretty high. For example, AIG has a very extensive system of offices and Arabic-speaking folks in Kuwait and I believe in Iraq. And in order to get started up in this market and to be able to compete in the market, I think it would cost a lot of money to get in. That may well be it, but I don't want to represent myself as an insurance market expert.
I understand. But you're going to have to do that. You're going to have to become an expert, because you're sitting here telling us that you believe that reform is necessary. And I do appreciate you saying that. Thank you for coming in here and not trying to snow us. But this is the key. If we are going to change the system, we need to change it soon, because in a few minutes some people are going to come up here and they're going to talk about their personal tragedies. The one thing that Chairman Kucinich will tell you is that one of the things that we try to do is get government to work for people. And so if a commitment made is a commitment that has to be kept. And it's part of our responsibility when you come in here and tell us that something is wrong and need to be corrected, and then after you testify, people who are victims of the system come up and tell us how they've been victimized, then if it's not changed, then we become a part of the conspiracy of failure and mediocrity. So now the question becomes, what's the timetable on all these changes that you're talking about? You've been kind enough to come in here and tell us that things are wrong, but that doesn't put one dime. Words don't put one dime in the pockets of these people whose families have suffered, who they have suffered, and who loved ones, surviving loved ones, are suffering. So can you give us some timetables so we're not doing the same thing next year this time?
Well, let me say, I agree with everything you just said.
Thank you.
And I hope that we're not here next year. I hope we're here next year talking about how to implement a new program.
The urgency of now.
Yeah, I agree with you completely. But let me also say, the timing is up to you. Congress needs to reform this program. The Labor Department can't do it. There are changes that we can make, but the fundamental reform that's needed is up to you.
Good. So, tell me, what do you think would be the most, you're the one who's in the department, what do you think would be the most effective way for us to address what you have already seen in the department? And will we have the support if we do what you suggest of this administration. After all, the president's going to probably have to sign whatever we do.
I don't want to represent that the president's going to sign whatever you do, but we need to have more discussion with the contracting agencies. We're dedicated to doing that quickly. We're going to get this report from the Defense Department next month. Congress dictated that they do it, and they're doing it. And then we're going to hopefully come to you with a proposal. I've tried to give you 4 ideas that you can begin working on immediately and try to assess how they match up with solving the problems that exist in this program. So I think we should get started with that discussion right away about how to get to a bill. But I must say, because we need to have some more discussion within the administration about which of these choices we want you to make, I want you to go ahead and get started, and we're going to come to you hopefully with an answer soon. But I can't tell you exactly when that's going to happen. Hopefully
Do
soon.
you think this profit margin of 40% is reasonable, or you think that's a bit high?
You know, Congressman, I'm not an insurance regulator, so I'm not really in a position to say.
All right, thank you, Mr. Chairman.
I thank the gentleman. Chair recognizes Senator Sanders.
Thank you, Mr. Chairman. As I understand it, and you tell me if I'm wrong, somewhere between 80 and 90% of the business that KBR let out for insurance seemed to go to AIG. Does that sound right to you?
I don't know the specifics of KBR's business. I was speaking with Congressman Cummings about the market as a whole and the Defense Department market, but I can't
That
speak
is my
to
understanding. The overwhelming amount of business from KBR went to AIG. And picking up on Mr. Cummings' point, above and beyond the terrible treatment that people who put their lives on the line to defend this country have received, it does seem to me at least a little bit strange that workers' compensation companies providing insurance in Iraq and Afghanistan have made underwriting profits of $600 million on $1.5 billion in premiums. I don't think you have to be an insurance expert to suggest that that may be war profiteering. Does that sound right to you?
It sounds like a lot of money to me. Again, I'm not the Labor Department. Again, just getting back to the Labor Department's role here, we're not insurance regulators. That's not our role in the system. Congress didn't give us that authority, so I'm just not in a position to say.
But your job, because we're playing with American taxpayers' dollars, that in this case goes from the taxpayers to the DOD, goes from the DOD to KBR, goes from KBR to AIG. What I think the taxpayers and the government of the United States expects is that when people in fact get hurt, they get justice. When they need medical help, when they need death benefits, their families need death benefits, they get it, and they get it in a prompt manner. Now, in my view, I don't want to get into a partisan sprawl here. I think the Bush administration will go down in history as one of the most incompetent administrations. And you guys are new on the job. But I hope very much, picking up from what Congressman Cummings just said, it is important that we turn the page on this issue. And it's important that you work with Congress to give us your ideas so that, A, we have a cost-effective program, we're not wasting billions of dollars, and number 2, more importantly, that when people get hurt on the job representing the needs of the United States of America, they get prompt and just compensation. Does that sound fair enough?
I agree with you, and let me go a little further. You have my commitment that we're going to work with you to fix this program.
Okay. Thank you very much.
I thank Senator Sanders, and the chair recognizes the gentlelady from California, Congresswoman Watson.
Thank you, Mr. Chairman, for holding this very significant hearing. I want to thank Mr. Harris for waiting all these hours while we played in the sandbox on the floor, because I think it's very, very important that we hear from you, the Department of Labor, because we had no idea when this new administrative group started that we would have the kind of unemployment. But a good friend of the people is now over there, Hilda Solis, and I know her staff will do an excellent job in trying to straighten this out. So according to data from the Labor Department and anecdotal evidence from federal contractors working overseas, the workers' compensation system currently in place is characterized by high denial rate, and you probably talked about this before I came to the committee, but characterized by a high denial rate for those requesting compensation, while the insurance providers have benefited from significantly higher profits than those typically earned by conventional workers' compensation insurers. This conflict is perpetuated by a seeming lack of comprehensive oversight of the system, and I hope that's something that we'll try to iron out. With oversight duties fragmented between the Department of Labor, the Department of Defense, and the Department of Justice. So what kind of communication has there been? I think you've only been there on the job 2 weeks?
About 3.5, ma'am.
About 3.5 weeks. Picked up a lot. So what kind of communication has there been between the Department of Labor, the Department of Defense, to control the high premiums paid to insurance companies and to ensure federal contractors are receiving adequate care?
We have been in discussion with the Defense Department about reforming this program and the study that they are undertaking. The Labor Department has no authority over premiums in this system. That is determined by the contracting agency that establishes the contracting relationship with the employer and establishes the relationship with the insurer. So we have no mechanism by which we can control those costs or regulate those costs.
As long as you're talking to each other, I would hope that you would mention that this is a serious problem and that our committee has questioned and to expect more questions from us. If you can pass that on.
I will.
And can you tell me why the Department of Labor only referred one case, and this is probably before you arrived, one case to the Department of Justice for prosecution of an insurance carrier knowingly making a false statement for the purpose of reducing or denying benefits to an injured contractor, despite evidence that such instances have occurred on numerous occasions? And if you have not been there long enough to know about this case, I wish you could get back to us and let us know what happened under the last administration to reduce the number of cases that would go for prosecution. And with that, I'll yield back my time.
I thank the gentlelady. I want to thank Mr. Harris for his presence here. This committee is adamant about making sure that the Department of Labor reforms its position on these matters to make sure that those who were injured are able to receive the compensation that they are entitled to. The committee thanks you, and we will be in touch with you. At this time, we're going to call the second panel. We're combining the second and the third panel. I'd like everyone to come forward. And while you're coming forward, I'd like to take this opportunity. We'll just move expeditiously to put the witnesses in place. While you're coming forward, I'm going to read some of the bios because we're going to keep moving this along. I also want to take the opportunity to thank those from the media who are here for their patience in waiting, the reporters, the cameramen, the technicians, and the producers, for your role in helping to communicate this hearing to the general public. So thank you very much for your presence. While the panel's getting into place, I want to talk about who we're going to be hearing from. Mr. Timothy Newman. Mr. Newman, welcome. He was a former civilian contractor in Iraq for DynCorp. In 2004, he joined the U.S. Department of State CivPol mission to Iraq as part of the global war on terror. He was 15 months in Greater Baghdad training the Iraqi police forces and protecting fellow mission officers until on September 2nd, 2005, he was severely injured by a roadside bomb. Mr. Newman lost his right leg and sustained several other major injuries. Upon returning home, he worked with DynCorp to develop a program to better care for injured contractors. Mr. Kevin Smith is a former civilian contractor who worked as a truck driver for KBR in Iraq. Mr. Smith was severely injured when his supply convoy was ambushed by insurgents outside Baghdad in 2004. John Woodson is also a former truck driver for KBR in Iraq. Prior to going to Iraq, he was a construction supervisor in Houston, Texas, working with cranes in the rigging industry. He also worked aerospace, commercial, and petrochemical fields for 25 years. On October 28, 2004, John Woodson was hit by an IED, losing his leg and most of his eyesight. Gary B. Pitts. As an attorney, he's been handling U.S. Department of Labor cases for the last 30 years. Since the war began 6 years ago, he'd been representing more civilian contractors wounded, injured, or ill from the war zone than any other attorney in the country. He's had over 300 ongoing Defense Base Act cases at all times for the last 4 years from all parts of our country. He's the owner of Pitts and Mills, Houston, Texas, served in the Army National Guard for 12 years and was a captain. General George Fay is Executive Vice President Worldwide P&C Claim of CNA. He's responsible for claim strategies and operations for CNA's property and casualty operations worldwide. He's also a member of CNA's Operating Committee. Before joining CNA in July 2006, General Fay was Executive Vice President and Chief Services Officer at the Chubb Corporation, where he spent more than 30 years in claims, operations, and administration, holding positions of increasing responsibility. He is also a retired Major General from the U.S. Army Reserve. Christian P. Moore is AIG's Executive Vice President and President of AIU Holdings, Incorporated. He's responsible for worldwide general insurance companies of AIU Holdings, Inc., a leading global property and casualty holding company. He's also an Executive Vice President of American International Group, Inc. Prior to the formation of AIU Holdings, Inc., Mr. Moore was President and Chief Executive Officer of AIG's Property Casualty Group. Finally, Charles R. Schrader, and he is going to be joining Mr. Moore for questions from members. Is that correct? You won't be making an opening statement, is that right? He is President of Worldwide Claims American International Group. As President of AIG's Worldwide Claims Operation, Mr. Schrader has substantial experience in addressing claims under the Defense Base Act and War Hazards Compensation Act. I would like all of the witnesses who are either going to be making a statement, answering questions, or both, I would ask that you rise, because it's the policy of our Committee on Oversight and Government Reform to swear all witnesses in before they testify. I would ask that, thank you very much, Mr. Woodson. I would ask that each of you raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Let the record reflect that each of the witnesses answered in the affirmative. You may be seated. As with panel one, I ask that each witness give an oral summary of his testimony, and to keep this summary under 5 minutes in duration. Your entire testimony will be included in the record of this hearing. And I'd like to begin with Mr. Newman. Thank you very much for being here, and to those who are here as contractors and have served, I think it is appropriate on behalf of the subcommittee to also say thank you for serving the United States of America. You may continue.
Thank you. My name is Timothy Newman, and I was injured in Iraq in 2005 while working for DynCorp as a civilian contractor. Since my injury, I have personally endured the effects of an outdated Defense Base Act and also advocated for other injured contractors through their ordeals. I grew up in Charleston, South Carolina. I joined the Marine Corps at 17 and became a South Carolina police officer at 22. After September 11th, I volunteered for the civilian policing mission through DynCorp International with the U.S. State Department. I landed in Iraq on the 4th of July, 2004, and hit the ground running literally. I served with the State Department training unit that worked to train the existing Iraqi forces. We traveled the BIOP highway several times per day, and my unit actually moved over 3,000 passengers without any injuries until September 2nd of 2005. Just after leaving our compound, my vehicle was hit by a roadside bomb. The blast completely blew through the driver's section of my vehicle. My navigator and friend of 20 years, Leon Vince Kimbrell, was killed instantly. The shrapnel and the blast tore off my right leg, shattered my left leg, almost severed my left wrist, and sent shrapnel through my lung, intestines, and chest. I was blown completely out of the vehicle and found myself with a useless body on a dirty Baghdad street. I dragged myself down the street until my team rescued me and delivered me to the Combat Surgical Hospital in the International Zone within 20 minutes of the attack. I spent the next 22 days in a medically induced coma and woke up in the U.S. military hospital in Longstuhl, Germany. This is where my personal story with the DBA begins. My initial care was amazing, and my treatment by CNA was good. I was appointed a local case manager who expedited my care and worked with the hospital. My care did not begin to fail until I left the hospital. In February of 2006, I was ready to start walking on a prosthetic leg, and by October, I was disillusioned with the absence and lack of communication by my former employer, DynCorp, so I wrote a letter to the CEO. In a few weeks, I received a phone call inviting me to Texas to talk about my complaint. I went to Texas with a shiny new leg and met my former bosses, and the meeting ended with a decision to start a program of employee care. I also left with a part-time job to start the new program. We made great headway in caring for our employees and started associations and programs to help them. We had far less success with our insurance carriers. The actions that we received from the insurance carriers and companies were simply lip service. Other than limited support for some of our programs, they did nothing to make the process easier on our side or theirs. It was typical double talk and empty promises. After 2 years of fighting, I left the program late last year. In 2007, my treating physician recommended I get a power knee system, a true bionic leg that acts in place and supplements the muscles that I lost. The legal battle for this leg took over a year and a half and resulted in me getting the system 557 days after it was initially requested. The administrative law judge that concluded the power knee was both reasonable and medically necessary found that CNA's experts, quote, "Neither physicians have opined with any degree of certainty that the power knee prosthetic will not address the claimant's need, and that both have little knowledge regarding the claimant's medical status and regular daily activities and have no first-hand knowledge of the power knee prosthetic." In October of 2008, 1 month after leaving DynCorp, my biweekly compensation checks began arriving, but were only half of what the amount should be. After weeks of no communication, CNA claimed that while I was employed by DynCorp, I was overpaid. So without warning or discussion, they cut my compensation to recoup their funds. Of course, their assumption of what I made was baseless, and at the time, they did not even have my pay records from DynCorp. I suffered through financial hardships for no real reason. My legal counsel requested a hearing on this dispute. It is now June, and our hearing is set for August, almost a full year after the problem started. In the 3.5 years since my injury, I have met and tried to help so many people who were damaged in our national defense. I have personally talked 3 friends out of suicide, and each of them suffered greatly from post-traumatic stress disorder, but their biggest battle was the one they were having with their insurance carrier to get real care for their problems. I know of more than one friend that did take their own life. I have helped and supported a friend facing double amputation for war injuries while the carrier said it was not medically necessary. I have helped a man who had an RPG go straight through him twice, who was denied help, support, or communication from their insurance carrier. I have seen friends with blast-related hearing loss be denied help and be forced to buy their own hearing aids while their cases went to court. I can continue on and on. I'm not an expert, but I'm a victim with common sense who has seen failures of our current system. In my experience, the single biggest cause of these failures is the insurance carriers' practice of seeking profit in every way possible from our fight for national survival instead of becoming part of the forces united against our enemies. When this act was written by Congress, they sought to provide an expedited workers' compensation system for war effort workers. Once the DBA carriers hijacked the system and saw it as a source of profit, the program was lost. I would like to personally thank you for your interest in this issue and your commitment to making a difference and your service to all of us, and I'm happy to answer your questions.
Thank you, Mr. Newman. Mr. Smith, you may proceed. And I would ask that you hold the mic close enough so we can hear your testimony. Thank you, sir.
Thank you, Mr. Chairman. Gentlemen, ladies of the committee, I appreciate y'all having me here today. This has been a long time coming, and I'm proud to be here. My experience with AIG has been traumatic at best. I thought everything was fine at first, and then as I needed more treatment, things began to get tougher. I couldn't get treatments my doctor recommended, like medication and sleep studies, so I did without, or I paid them for myself, which has greatly hindered my continuity care and thereby increasing the time it has taken me to achieve the goals dictated by my medical providers. And the trauma associated with the PTSD is nothing. I mean, nothing compared to the trauma myself and my family has had to cope with because of AIG's blatant incompetence and egregious behavior. In 2 separate instances, AIG has stopped paying my indemnity. The first time was in November of 2005, and then again in November of 2007. In November of '05, the benefits were reinstated, but it took several months before I started receiving my checks again. Then I had to fight to get the checks I had missed. I started investigating and was alarmed to find out that my doctor had not been paid for procedures or office visits from '04. Although AIG would approve the treatment, they would not pay. So the doctor that saved my leg and possibly my life was considering not treating me any longer. In November of '07, AIG completely stopped paying all benefits, including medical, that I'm supposed to receive for life, according to the DBA. They refused to pay for another surgery needed on my knee or any other doctor's care. They would not even pay for medication I was taking for the PTSD. Basically, they completely ignored the fact that I had been diagnosed with PTSD as a result of my experience in Iraq, and they have used some of the most ridiculous excuses trying to defend their position. And to top it all off, they tried to say they had overpaid me by $23,406.60. I had to endure a long, grueling battle to reinstate the benefits that should have never been stopped. During this time, my family and I still had to live, so I was forced to return to work in a job that exacerbated my injuries to my leg and the PTSD. They stopped benefits based solely on the fact that the schedule on my leg was paid out without considering I was still being seen by a psychologist, which I might add, they approved. They obviously knew they had no legal grounds to drop me, but I guess that's part of the game they play in order to wear people down so they will no longer have the will to fight. My attorney put in a request for an informal hearing with the DOL, the Department of Labor, which was denied. We appealed that and got our hearing, in which the hearing officer found in favor of me and ordered that the benefits being reinstated. But in AIG's normal fashion, they acted with impunity and continued to deny benefits. We then requested a formal hearing with an administrative law judge and were heard on 30th of July of '07. Judge C. Richard Avery found that I should in fact receive all benefits and back pay with interest, plus all out-of-pocket expenses, and all the doctors be paid. AIG has still failed to comply with this order entirely. They have not called and approved my treatment for PTSD. They have denied payment for medications. They have just now made a partial payment to my doctor for services rendered back in '04. And I want to point out the partial payments, ladies and gentlemen. They only paid less than half in most cases, and never, I repeat, never have they paid in full. In summary, I have provided this committee with facts that I've backed up with evidence of AIG's downright criminal handling of cases of American men and women who put their lives in peril for this great country. All personnel serving in a hostile foreign land must be taken care of when they return home, whether they served in the military or as a civilian contractor, because we did what most people would not do. Therefore, we should all be considered by our country as the heroes we are. A large portion of the contractors, like myself, were veterans of numerous hostile engagements and volunteered to go to Iraq for the chance to once again serve their country. And we demand that we receive the care that was promised us and we deserve. Listen, we're not asking for millions of dollars of bonuses. We're not asking for lavish parties or even parades. We want what we're entitled to under the Defense Base Act, like medical care, disability pay, and retraining if necessary. Thank you.
I thank Mr. Smith. Chair recognizes Mr. Woodson for 5 minutes, and I just ask you to make sure that mic is close to you so we can hear your testimony.
And my two colleagues here have covered quite a bit here and said a lot.
I would ask staff to assist Mr. Woodson and bring that microphone close enough.
Is that close enough?
We can test it and make sure it's on.
Is that close enough?
Oh, that, Mr. Woodson. We can hear you loud and clear. Thank you.
Okay, bear with me here, please.
Just you take your time. Go ahead.
And thank you all for having me here, having all of us here. I would like to thank each and every one of you as much for inviting us today to share my experiences with you, and my name is John Woodson. Prior to going to Iraq, I was a construction supervisor in Houston, Texas, working with cranes and rigging in the rigging industry. I worked aerospace, commercial, and petrochemical fields, investing 25 years of my life. In late 2003, KBR representatives contacted me asking if I had a thought about going to Iraq and help rebuild the country, which to me that was a great opportunity to provide my contribution to this country. So I left in June of 2004 to go to Iraq, and unfortunately I was blown up by an IED blast on October 28th, 04. Now here we are in June 2009, 5 years later, and I am still wondering why events have happened the way they have. After waking up from a medically induced coma at the Methodist Hospital in Houston, Texas, I was sent to a rehabilitation facility called TIER. There I was visited by a James Heil from ASG. He was a representative adjuster and investigator working for AIG Insurance. After seeing my condition, he stated that there wouldn't be any problem because AIG was going to take care of my life and everything involved. A statement that will shortly turn out to be untrue because the first problem quickly arose. The first problem was my money. Nothing was being deposited into my account. My wife, brother, and daughter then spoke with Mr. Hall about the issue. He told them that the situation would be looked into. Several weeks later, I did receive a deposit, but the weekly average was lower than what had been spoken about. At that point, I called AIG Insurance and spoke to Jim McIntyre, who refused to talk to me. He flatly said to me, hire an attorney, and AIG would discuss the issue with them. At first, I wanted to believe that it was just a small misunderstanding because it was a new account, but the reality soon sank in, and the result would be larger than I could even imagine. The conflict that started then is still going on today. Every aspect is a disagreement, a complex and infinite process from medical, money, pharmaceuticals, transportation. Even the Department of Labor in Houston has not been any help, and I am just naming a few of the list on the list, and it is really too long to write. Ladies and gentlemen, due to my vision impairment, speaking about this matter would be much easier on me. It'd be much more conducive. And as of April 24, 2009, my case has been turned over to the U.S. government, and I still haven't noticed much of an improvement. In conclusion, I asked why. Where has the oversight been, and who is in charge of this operation?
Mr. Whitson, thank you very much for your testimony. The Chair recognizes Mr. Pitts.
Thank you, Chairman Kucinich and Ranking Member Jordan, Congresswoman Watson, and Congressman Cummings. Thank you for starting this process. And thank you for your interest and attention to these brave men and women that go over there and fill in for what the Army used to do. Okay. I've had the opportunity, the privilege of representing hundreds of them, and based on that experience and on 30 years of operating before the Department of Labor, here are my 5 recommendations to make this system work more quickly and better. First of all, there hasn't been any additional funding since the war began for the Office of Workers' Compensation Programs and the Office of Administrative Law Judges. Whereas AIG, for example, had 3 adjusters in 2004 in Dallas that handle these cases. Now we have about 30, a tenfold increase. So there's been no increase at the Department of Labor. There are some, for example, the OALJ could use some video conferencing equipment. That sounds pretty mundane, but that could help a lot. Maybe cost $200,000 to outfit all of them with video conferencing equipment. Right now, we have to do a circuit. We're like the Old West. We go to the claimant, the judge does, I go, and the defense attorney. If we had video conferencing equipment outfitted with the judges, we could have those conferences done more quickly. We could move this process along. It'd save money from having to send the judge there and back. It'd save his time. Second thing I would suggest is on PTSD, it is taking about a year and a half to work through the system before somebody can get treatment. The contractors don't, the Army in contrast, they tell people what the symptoms are before they leave the theater. They check back up on them 2 or 3 months later. Contractors don't have any of that. They get back, they start having symptoms, their family sends them to get some help. They enter the process of litigating their case. This is a wasteful system like it is because the litigation costs are eventually going to get put off on the taxpayer. I'm trying to work myself out of some work here. All these people should immediately be able to go to the VA. They're coming out of the war zone. They should just go to the VA. The VA is set up for taking care of PTSD. Just let them go there, get in line with everybody else with the group therapy. There's less chance of them hurting themselves, hurting people around them, and that's economical, it's efficient, and it's an exception. There'll be some people that say, well, they're not in the military, they shouldn't be able to go to the VA. This is an exception. They're right there next to our soldiers. The enemy doesn't distinguish them from our soldiers. If they've got PTSD uniquely situated from coming from the war zone, just let them go to the VA. Third thing is there is presently no requirement that if one of these men is killed over there, that the widow acknowledge that there's such a thing as death benefits. There's a possibility of death benefits under the Act, or surviving spouse. There are also ladies over there. That could be easily remedied. Just basically, the employer would have the obligation to get a one-page acknowledgement from the widow saying, I understand there's the possibility that I may be able to be entitled to death benefits under the Defense Space Act. And they ought to be able to attach that to their paperwork in order to get paid, or they don't get paid by the government, or they don't get a new contract. This should be able to be enforced quickly so we don't have the anomaly of some lady in a small part of the country with a house full of children and their breadwinner's dead, going on government relief because she hasn't figured out what the Defense Space Act is and how to fill out the right form to file it with a New York office within a year, the statute of limitations. So that's a little gap that can be taken care of. The fourth thing I would suggest is there's now really no stick for the administrative law judge. And let me point out, make this clear, nobody can make the insurance company do anything except the judge. The Department of Labor has no power to make them do anything. They can give informal recommendations, which we have to have in order to have the case come up to be assigned to one of the 40 or so administrative law judges that hear these cases. But we have to go through this process and litigate these issues in order to get resolution. Now, they'll do what the judge tells them to. They have to. Well, we have some problems sometimes, even with that. However, the judge is really the only one that can make them do things. So if we can beef up the OALJ, they used to have like up 100 judges to do the black lung docket. They need some extra ones. You can see from my paper, the trials have gone from 95 in 2005 to about 578 scheduled this year. It's a 5-fold increase. They need some help. They haven't been any additional funding. So anyway, what I'm suggesting is the judge needs a stick. At this point, all he can do is make them do what they should have done to begin with. Plus they have to pay my time for having held them down and make them do something, and they have to pay interest. But it's at short-term Treasury rates. So these gentlemen, if they go through litigation and the judge says, like Judge Avery did, in Mr. Smith's case, you got to pay this, they also only have to pay like half of 1%. That's the interest they have to pay. So the judge should be able to, if there's
the gentleman wrap up his testimony.
And he should be able to assess a 15% penalty for a 10% penalty or whatever, for a frivolous defense. In addition, they can profit by CFR, 20 CFR 61.104. They can add 15% handling fee for litigating a War Hazards Act claim. So if they're hurt from enemy action, they can profit by litigating it. That needs to change.
Thank you very much, Mr. Pitts. We'll now hear from General Fay. You may proceed.
Thank you, Mr. Chairman. And
Please please speak, draw that mic a little closer, please.
Is that better, Mr. Chairman?
A little bit closer. We want to hear your testimony. Thank you. Go ahead.
Okay, thank you, Mr. Chairman.
Thank you.
And thank you, Ranking Member Jordan, and the distinguished members of the subcommittee. Thank you for the opportunity to appear before you today on behalf of CNA Insurance. I am George Fay, Executive Vice President of Worldwide Property and Claim for CNA Financial Corporation. I have more than 30 years of experience in the insurance industry. I retired from the United States Army Reserve as a Major General in May 2008 after 38 years of service, including almost 4 years on active duty in support of the global war on terrorism and Operation Iraqi Freedom. During those 4 years, I served in many parts of the world, including Iraq and Afghanistan, side by side with defense contractors in every location. I share the subcommittee's view that civilian workers in Afghanistan, Iraq, and elsewhere around the world are performing a crucial service for this country and that they deserve fair treatment in the administration of insurance claims. I understand well the sacrifices being made by the men and women who support our military operations abroad, and I am pleased to be part of the CNA family that takes great pride in supporting those that make such great sacrifices. CNA understands that this hearing focuses on 2 categories of concern under the Defense Base Act: claims handling and underwriting gains. With regard to claims handling, I would like to address some errors that were made in the majority staff's June 16, 2009 memorandum addressed to the subcommittee. The memo implies that CNA has a record of unnecessarily pushing claims to administrative rulings. This is misleading. In fact, of the approximately 5,500 claims that have been filed, CNA believes that fewer than 20 of those claims, less than 0.4%, have gone to administrative rulings. Of those cases, CNA has lost only a handful. Even in the cases that CNA has lost, there was never a finding that CNA acted in bad faith or advocated frivolous positions. CNA's experience is consistent with the written statement of Seth Harris, who you just heard from before, as the Deputy Secretary of the Department of Labor, which noted that the DOL has found no deliberate intent to delay claims handling. His statement is borne out by the numbers I have set forth in my written statement. We are contacting insured workers and their companies within 24 hours, 86% of the time. And despite the strict, we believe too strict, requirement to make a compensability determination within 14 days, we have been able to make that determination within those 14 days 75% of the time. Related to the underwriting concern, it should be noted that the overall CNA DBA underwriting gain from 2002 to 2008 was only 14%. Moreover, CNA's role in the at-large part of the business on which the subcommittee is focusing today has been minuscule since 2006, with only about 3% of the market share. In contrast, CNA is currently the only provider of the widely praised program contracts, which are awarded through a bidding process. In 2008, Chairman Waxman lauded this process and highlighted CNA's presence in the market. We concur with those who suggest that the program contracts are the solution to the DBA underwriting concerns. CNA would be happy to work with the subcommittee to improve the process governing DBA contracts. Therefore, Mr. Chairman, I thank you for the opportunity to discuss these issues today, and I would be pleased to answer any questions that the subcommittee has.
I thank the gentleman. Mr. Moore, you may proceed. Please bring that microphone close so every member of the committee can hear your testimony. Thank you.
Mr. Chairman, Ranking Member Jordan, and members of the subcommittee, thank you for the invitation to appear before you today. AIG is pleased to participate in this hearing examining Defense Base Act DBA insurance for federal contractors working overseas. Given the importance of this issue, AIG looks forward to working with the subcommittee on ways to improve the DBA program to ensure proper coverage for contractors. The DBA program is one of the many lines of coverage offered by AIG's General Insurance. In order to provide the subcommittee with a better understanding of AIG's participation in the DBA program, I am joined today by Charles Shader, President of AIG's Worldwide Claims. Mr. Shader has 25 years of experience in insurance claims management, including the extensive experience with the DBA program. He has provided testimony for the record that outlines AIG's participation in the program and identifies several areas where we think the program can be improved. AIG has had a long and proud history of providing DBA coverage. While other insurers participate in the DBA program, no other insurer has created a center of excellence for the care of injured workers comparable to ours. AIG has also made significant investments in our claims management process to facilitate our participation in the DBA program. AIG now has claims professionals located in 6 global offices that are equipped to handle unique regional and local needs. As but one example, the Dubai office staff is fluent in 4 languages. It has developed expertise in overcoming geographic and cultural obstacles, paying benefits in country in local currencies, and conducting investigations in the Middle East to locate claimants while obtaining witness statements and verifying dependency. As Mr. Shader has identified in his written statement, AIG believes that there are 3 key areas where the DBA program can be improved through a combination of legislative and regulatory reform. First, providing detailed, accurate status reports to claimants instead of the LS 207 controversy notice. Second, rationalizing and simplifying the calculation of average weekly wage, and interagency cooperation on the diagnosis, prognosis, and treatment of post-traumatic stress disorder. Thank you again for the opportunity to participate in today's hearing. We look forward to answering any questions the subcommittee may have. In particular, Mr. Shader will be able to speak in greater detail regarding the DBA practices.
I thank the gentleman for his testimony. General Fay, I was interested in your testimony. There seems to be a variance from your, according to staff, there seems to be a variance from your prepared testimony to what you presented to this committee, in that you quoted from a internal committee document that hadn't been released, and that was really the property of this committee. I just wondered, where did you get your information from?
I was given that by a member of our staff, sir, but I don't know where exactly they returned.
What was the name of the member of your staff that gave that to you?
It was our head of...
Remember, you're under oath. Who gave it to you?
Yes, I got it from our head of legislative affairs.
Is your head of legislative affairs here right now?
Yes, she is.
Who's that? Would they identify themselves? Would you like to come to the committee table? Do you want to identify yourself?
Yes, I'm Heather Davis.
Would you like to be sworn? Do you have an attorney here?
No, I mean, we have several attorneys on staff. I'm not an
Okay. Would you raise your right hand? Yes. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Yes, I was referencing an internal document that had not yet been released that was quoted by General Fay. He said that you gave him that information. Is that correct?
To be completely honest, I was working with Mr. Watson here, who was with our parent company, and it could have been either one of us that gave it to Mr. Fay. Can you hear me now? I was working with our parent company lobbyist, Lowe's Corporation, Mr. Watson. It was either he or I that gave it to him.
Where did the document, he said, Mr. Fay said he got it from you. Where did you get it from?
We were, I want to make sure I'm clear, we were doing a lot of visits on the Hill. Steve, do you recall where it came from?
Committee staff? Which committee staff? Democratic committee staff? We're going to, this isn't, this is tangential to the purpose of this hearing, but you are going to be subject to further questions from our attorneys where that document came from. It's really somewhat unprecedented for information to, that has not yet been released to the public to be in the hands of a witness who then uses it to criticize a committee report. And this is something that we're going to find out who gave you that, and then we'll deal with it as an internal committee matter. Yes, Mr. Jordan.
Well, Mr. Chairman, I've just checked with the staff that is present here. They indicated that they did not give that document out. I certainly didn't. Don't know of anyone on our staff who did. And,
well, you know,
this is highly unusual too, that we bring in people from the audience who haven't been cleared. We don't know are going to be witnesses.
I didn't expect that General Fay would be giving testimony that would reference an internal report and then say that he himself did not know where that came from, but referred to someone else. That's why we did it. Now, we are not going to change the subject of this hearing, but I just want you to know, General Fay, and I want the gentlelady to know and the people in the audience who are involved, that you are going to be subject to further questioning about this. Now, thank you very much. You're dismissed. General Fay, we've heard from these witnesses, from Mr. Newman, Mr. Smith, and Mr. Woodson, all about their problems in getting paid by various people. Mr. Newman is the one that had the experience directly with CNA. Is it the policy of, well, let me put it this way. Would you provide for this committee your internal documents with respect to what your strategies are for denial to increase your corporate profits?
We have no such documents that have that kind of a strategy. I wouldn't be associated with a company that had such a strategy.
So you're saying that you don't make money denying claims?
That's not exactly what I said. I said.
Do you agree with that
Mr.
statement? Does CNA make money denying claims?
That is not what we're in the business to do. We're in the business to insure people for the risks that we are insuring, and when the claims are legitimate claims, according to whatever the insurance policy is that we issue to them, then we pay them. We pay them promptly. We pay them according to the law. And we take great pride in doing that.
We have testimony that contradicts that. What I'm going to do, my time has expired, but I want to indicate we're going to have a second round, and we're going to come back to General Fay and Mr. Moore about the testimony that we're hearing about your claim denials and whether or not you have a conscious strategy as a business to deny claims to people who have been injured or killed in a war. The chair recognizes the gentleman, Mr. Jordan.
Thank the chairman, and let me just begin by thanking all our witnesses, and in particular those of you who have been serving our country in a war zone. We certainly appreciate your sacrifice.
They can't hear you.
Okay, I just said I wanted to thank our witnesses, in particular those who have been serving on the front lines. Mr. Pitts, you talked about in your testimony problems both with insurers and with the Department of Labor, and you had some, I thought, some good practical recommendations in your testimony, putting families on notice that there would be a death benefit in the event that that tragedy took place. I think in point number 4 you talk about frivolous claims, and also when
actually frivolous defenses.
Pardon?
We've always heard about frivolous claims for 10 years, but this is a frivolous defense. You know what I mean? Frivolous.
Claimant brings a frivolous, but you also talk about bad behavior on the part of insurers.
Yes.
Just as a general question, where's the bigger problem? Is it the lack of oversight, lack of is it the government or is it the insurer?
No.
I mean, you've brought, I think you said hundreds of cases. Where do you see the real concern?
There's a defect in the law that needs to be changed. It wouldn't be difficult. Here's what it is. Under the present Code of Federal Regulations, and this is my fifth point, it's not in the, an insurance carrier, it's not necessarily these gentlemen, any insurance carrier is in a position where, you know, amorally or whatever, it is in their interest to litigate a War Hazards Act case because under 20 CFR 61.104, they get their litigation costs back. They get their attorney's fees back, and they get to add 15%. Okay? You can't get 15% in a CD now. You can't get 15% assured in the stock market. It's a great deal. So let's say a PTSD case, and this has happened, where the claimant's doctor said he's got PTSD from the war zone. The insurance company doctor agreed. He's got PTSD from the war zone. Nonetheless, the case was litigated all the way to completion, and there was a judicial finding, yes, this guy has PTSD from the war zone. Within 6 weeks, the War Hazards Act bureaucracy had picked it up and said, okay, now you're going to get all your money back. All that litigation costs that the defense had, they get to add 15%. So if it costs $20,000, they get how much, you know? So not only do they have the opportunity to defeat the claim, they drag it out. Who's suffering in this is the guy with PTSD or other kinds of injuries. So about half of these cases are because of enemy action. They're going to get probably picked up by the War Hazards Act eventually. So if that was modified they get, you know, a handling fee of short-term interest rates, which is what these men get. They get about a half of 1%. So if that's what they got, you know, and it would fluctuate with times, that would be more appropriate. But as it is, there is a built-in incentive for the carrier to profit from litigation.
How many cases did you say you had handled? 100, I think you said?
Well, I have about more than 300 going on at any one time over the last 4 years.
How many of those cases are PTSD?
About 20%, which is about the same ratio as the soldiers coming out of the war zone. My most frequent demographic is a truck driver hit by a roadside bomb.
Talk to me about, you were critical in your testimony of the Department of Labor, and as I said in my first round with Mr. Harris, you know, second time we've had, second hearing that's dealt with the Department of Labor, first time we've had someone from the Department of Labor come and testify, and the person they send has been on the job 3 weeks. You know, it's something this important, you would think they would send someone, nothing against Mr. Harris, but send someone who's been on the job a little longer, had a little more experience with a critical program. So tell me about your concerns with how the Department of Labor's failed to handle their responsibilities.
I think both the Department of Labor, Office of Workers' Compensation Programs, which is only about, 200, 250 people or so in the country that do this stuff, and the Office of Administrative Law Judges, which is about 40 judges and their staff, have done a great job with the resources they have. The system is not set up so that the OALJ, or rather the OWCP, gets to tell anybody anything. They can give recommendations. But if a carrier can litigate and profit off of it, it doesn't do anything. They give their recommendations, they're ignored. We go into litigation. It takes about a year or so to get finally a judicial decision to enforce. And during that time, they're hanging on to the money, and they get the end of it. If it's a War Hazards Act claim, they get to get some money plus 15%. The 15%. So I think that's been the problem. If you take that profit motive out of it, that incentive psychologically, subconsciously, whatever, if you take that out of it, and if they can get hit for some penalty, 10%, 15% for a frivolous defense found by a judge, this was a frivolous defense. They had no defense, it's frivolous. If they can get hit by 10 or 15%, it hits their pocketbook, I think that would be reasonable.
Okay. Thank you, Chairman.
I thank the gentleman. Chair recognizes Mr. Cummings from Maryland. You may proceed for 5 minutes.
Thank you very much, Mr. Chairman. As I sit here and I listen to all of this, it seems that we're talking in two different universes. We've got one with these gentlemen who have been harmed and who continue to suffer, and then we've got the insurance companies that sound as if they are operating the greatest operation in the world and doing every single thing that they can for these gentlemen, and it is a sharp contrast. To Mr. Moore, according to a Los Angeles Times ProPublica story, AIG stopped paying disability benefits to a civilian contractor whose leg was shattered by an insurgent ambush in Baghdad and who suffered from PTSD even though some of your own experts diagnosed him as partially disabled. Further, some 4.5 years later, in 2008, an administrative law judge ruled that AIG had failed to offer medical evidence to support its position that the contractor's PTSD was not caused by the convoy attack. The article, which was published in April of this year, states that AIG has still not paid Mr. Smith's outstanding medical bills as ordered, I suppose pending AIG's appeal. My question is this: on what basis is such a determination made, if not on the opinion of AIG's own medical experts? How is the legitimacy of a claim determined, and how many claims has AIG denied in which your own expert has sided with the insured?
Congressman Cummings, Mr. Shader would be much more qualified.
Make sure you we want to hear what he has to say.
Okay, sure.
Nice and loud, please, sir.
Pardon?
I want to hear you.
Oh.
And these gentlemen want to hear you, too.
Yes. You know, we do agree that there are many...
The witness is directed to put the microphone closer so that everyone in this room can hear you.
I'm sorry. Is that better? Yes. We agree that there are many changes in this system that would help in its administration and provide a better product, faster, quicker compensation, clearer rules for those people who have been hurt overseas, and as severely as these individuals have been. And, you know, I want to make it very clear on behalf of myself as well as my company that we really do owe them a debt, and this is not, you know, anything vindictive or a corporate policy of denial or, you know, it's a question of administering programs under an act that is ill-suited, and I have, in my written statement, submitted at least 3 fairly detailed areas of reform that would help. And I think increasing Labor Department oversight and administration would be of greater assistance, making it more like a state workers' comp agency would help. There are some claims that are very, very complex here. And we have provided some files to the committee, and it's hard, almost to the point of impossibility in the few minutes we have, to go through the steps of Mr. Smith's claim, piece by piece, to show why what we did was right under the benefit levels and the rules that we have to deal with. And I've offered to meet with the committee or the staff of the committee and bring in any member of my staff to go through those with you, and I'd be more than happy to. And if it would aid in the reform of the system and how the benefit levels are calculated, I would be more than happy to do that.
Let me ask you this. The aim of workman's compensation is basically no fault. Is that right? In other words, to expedite the claimant's workers' so that the worker can recover once they have an accident or a problem. Is that right?
I absolutely agree with that.
And so basically what is happening here is that although the insurance is for the purpose of moving a claimant along so that they may be compensated quickly so that the claimant doesn't have to end up having to file suit. That's what workman's compensation was all about. When I was in the state legislature, I was an expert on workman's comp. I know the federal may be a little bit different. And it seems as if, to me, AIG is doing just the very opposite of what workman's compensation was supposed to do. It was supposed to expedite claims. It was supposed to give people like Mr. Smith an opportunity to be able to get well and to move forward. But before you go on, since I have Mr. Smith here, Mr. Smith, what do you think of this testimony? I'm just curious. This is your case.
Thank you, sir.
The time's expired, but the gentleman may respond to the question.
Thank you very much,
Take
Mr.
the time that you need.
Thank you, Mr. Chairman. Mr. Cummings. My question for AIG pointed out increasing the funding for the Department of Labor, increasing that area. My question to you, sir, is what good would that do? Because you don't listen to what they say anyway. I have documented proof where AIG has ignored the recommendations of the Department of Labor. And then we have to continue to go through legislation again and again and again. So the Department of Labor is fine, sir. Your company is not.
Thank you, Mr. Chairman.
This will permit AIG to respond briefly.
Yeah. We have not been sitting on Mr. Smith's, excuse me, we have not been sitting on Mr. Smith's claim and refusing to pay and making arbitrary decisions.
Mr. Smith?
Sir, I have documentation of it.
You want to submit documentation to this committee?
It's in my statement.
Okay, Mr. Schrader?
I would like to add that we've paid over $500,000 on Mr. Smith's case in medical and indemnity to date. There are no medical bills outstanding today.
Was that the total of your bills, Mr. Smith?
That's indemnity as well. That's
no, sir. That was not the total. That's a falsification. They have not paid my doctors in full. They have paid what they thought was acceptable. And I have proof, I have documentation where they paid for services on a particular date. When they cut the check to the doctor, it was less than half, and in some cases just a small percentage of what that was actually owed. If he wants to ask me about it, I have that documentation, and I will provide that to the committee.
Do you want now, do you have that documentation, Mr. Shader?
I don't have it, and I would be more than happy to.
Do you want to give it to him right now? Yeah, just you want to make. Do you have copies of that? If that's in the record, we have to make sure that since Mr. Smith is referencing it, Mr. Shader is entitled to copies of it.
I would like to add in addition.
And if you want to examine those later, examine them now, and if you want to comment on them later, you'll be permitted to do that.
Thank you.
Okay, so we're gonna move on.
Okay.
Well, you'll get a chance to respond, but I think you ought to examine the documents that he gives you, and then you can respond. We'll make sure you get the chance to do it. We're going to go to a second round of questions here.
Mr. Chairman, I apologize to the committee.
Excuse me?
I apologize to the committee. I will make that available within the next 24 hours.
You're saying you don't have it with you right now?
No, sir. I left it in the hotel room.
Please make it available, and then we'll get it to Mr. Shader, is it? Shader, yes. And then we will send further questions from the subcommittee to you so that you have a chance to answer them in light of what Mr. Smith has said. Is that fair?
We'd be more than happy to do.
Is that fair?
Yes.
Okay.
Absolutely.
Okay. I want to get back to the line of questioning that I was working on. General Fay, you testified that CNA's average yearly profits for all of its Defense-Based Act insurance from 2002 to 2007 was of, excuse me, and I apologize, the gentlelady from California, Ms. Watson, is entitled to 5 minutes of questions, and I
thank you so
want to
much,
thank
Mr.
the gentlelady.
Chairman.
Please proceed.
I know you're on a roll here, and I
no,
don't
the gentlelady's
mind
entitled to her 5
deferring
minutes.
To you.
Go ahead. No,
because
please,
you're going
please
down
go ahead.
the same line I would go down. But I want to thank the gentlemen who have been out protecting our country for coming here in such a civil way and explaining what has happened to you. I think it's reprehensible that the insurance companies would hold up or delay. I think your kinds of cases should be number one. And to have to come here and testify in public to get the insurance company to take a deeper look at your request, I think is just an injustice to those of you who've been securing our own country. So thank you for being here. Thank you for your patience. Listening to your testimony, if you cannot be compensated for your wounds, both emotionally and physically, I don't suspect contractors' families get any compensation for what they have. And I'll direct this to Mr. Pitts.
Yes, ma'am.
I know that in our U.S. government contractors and subcontractors law, there was no reference to a contractor's family members or dependents except for the instance of compensation benefits for survivors of covered workers who were killed on the job. Is there any way to assist the families and the loved ones of these victims?
Beyond the death benefits,
Yes,
Congresswoman?
beyond the death benefits.
Beyond
Those
the
that are alive. and still suffering?
Well, I think if their husbands were taken care of correctly, that would be the best benefit.
But there is no benefit for
there's no benefit. I mean, unless a contractor dies as a result of his work over there, there's no benefits that go to the surviving spouse or the minor children.
So they would have to seek private insurance. You know, when these gentlemen come home,
yes,
there's care that has to be given. There's services that have to be given.
Yes, ma'am.
Food, clothing, and shelter. And so there's no way for them to be covered for these expenses?
In rare instances, there have been cases where I've been able to get some compensation for, let's say, a wife that has to leave her job to come home to take care of her husband because he's so badly injured he can't take care of himself. So there have been cases where we've been able to get, you know, compensation through the judges to do that.
I was listening very closely to your recommendations of how we should close these gaps. And Mr. Chairman, we might want to, from this subcommittee and our hearings, recommend legislation and policy that will not only cover the victims themselves, but their families as well. Because I don't care whether they have to work and come home, it still is a burden on them to have someone who has not been compensated for their illnesses, their providers have not been compensated fully yet. So I think that this is something, Mr. Chairman, that could grow out of the testimony here. I would think that all of those recommendations that you made should include conversation, and I'd like for you to, I think they were in your testimony, the recommendations, Mr. Pitts?
About basically making sure that the
recommendations.
Yes, the second one about making sure the widow knows, you know, that there is such thing as the Defense Space Act and that she may have a claim for her family, because I'm afraid otherwise there's going to be some really injustices out there because they just don't know any better. I mean, you know, if you're in a small town in, you know, Texas, what's the chance? I mean, your husband's a truck driver. He goes to work to support the troops over there. He dies. And so what's the chance that you're going to figure out there's such a thing as the Defense Space Act and to fill out the right death claim form to file it with the New York office, you know, in a timely way? That's just a gap that shouldn't be, and the employer should have some obligation to get her acknowledgement she's been told about this. I think that's reasonable.
The gentlemen to your left, are they your clients?
No, they're Toby, what's Toby's last name?
Cole. Tobias
Yes, Toby Cole, who's an attorney in Houston also.
What I'd like to see you do, and you gentlemen too, recommend to us how we can better the system so the benefits can reach out to the people they're intended to. These are contractors. They might not have been fighting, but they were in theater. And we owe them that. And I have been with insurance companies, and there's a point at which they just, you know, kick you out because your claims have been too large. I've been through that myself. But we want to improve the system, and particularly this bogus war that we fought over in Iraq. And these gentlemen went over to assist. And they should be treated like this after their severe injuries. So this hearing is to collect the information, and I hope, Mr. Chairman, that we will end up with some recommendations to put into a policy. And with that, I yield back. I already have the red light. Thank you, Mr. Chairman.
The chair will begin the second round of questioning. 5 minutes.
Yield for just a second.
Yeah,
you were consulting with staff, but I would hope that out of our hearings would grow some policy that we can give to the full committee dealing with insurance and insurance claims and so on.
Our role as a Committee of Government Oversight and Reform. We do oversight and reform. And so we'll work with the gentlelady, with the ranking member, Mr. Jordan, Mr. Cummings, and every member of this committee, because we do want to change this, no question about it. But before you change it, so that you know the direction you're going, you have to find out what happened. We have to do some forensics here. And the forensics may not be pretty. General Fay, you've testified that CNA's average yearly profits for all its Defense-Based Act insurance from 2002 to 2007 was 14.6% and only 9% from 2009. Now, isn't it true, however, that you have failed to mention that CNA's profits for all of its Department of Defense Defense-Based Act business, where CNA contracts directly with defense contractors, the business under scrutiny today, that those profits are over 50% per year, as based on documents that were produced from this committee and I believe obtained from you?
Yes, Chairman. The truth of the matter, the facts are that on that non-program business, which is the business that we at CNA agree with all the recommendations, that that's the line of business that should be changed, and that, in fact, the DBA program should be written under a program business.
But when you said 14%, I just want to clarify, I want to clarify the record here, because it's about numbers. You gave some numbers in your testimony. When you said it's only 14%, isn't that the profit number for all of your DBA business, including the single risk pool programs with agencies other than DOD?
Yes, that's correct.
Thank
it's
you. Now,
all of them taken together.
Okay, and
yes,
I just want to make sure that that we put that in the record, and without objection, we'll enter the record statement and the records from CNA, which state that a projected combined ratio for profit was 50%.
That's on the non-program business only.
Thank you. That's the subject of
only
this hearing.
3% of the market.
The subject, that is the subject of this hearing. 50% profit, and we're hearing some witnesses. It may give us an idea why you have 50% profit. Now with AIG,
we agree it should
Mr.
be
Shader,
changed.
You have touted AIG's handling of your PTSD claims in your testimony and in documents provided to the subcommittee. Yet, are you aware that AIG has repeatedly utilized the expert testimony of a psychiatrist to review and ultimately reject PTSD claims of insured civilian contractors who were injured, who freely and repeatedly admits both under oath and to reporters that he is neither an expert on PSD nor on MMP-12?
No, I'm not sure who you're referring to.
I'm referring, actually, are you an expert on PTSD?
No, I'm not. As a matter of fact, one thing I do want to say about that is I had talked to the Labor Department 2.5 years ago about sharing and reaching out for expert assistance from the VA, who I think does have the best cadre of experts. And I do want to say that it may surprise Mr. Pitts, but I actually endorse completely his recommendation on the handling of PTSD cases.
Mr. Pitts, have you experienced with Dr. Griffith?
Yes.
And you want to tell us about that experience?
Well, basically, the vast majority of people that he's seen, he says, don't have PTSD.
You want to hold that mic closer?
Yes,
We're having trouble
yes,
hearing
excuse me. The vast majority, he says, don't have PTSD. He has reservations about whether there is such a thing.
Did they repeatedly find, in your experience, that claimants were malingerers?
Normally.
Do they routinely, do they use real experts in evaluating PTSD?
Well, Dr. Griffith has said that he's not an expert in the MMPI-2, which is the Minnesota Multiphasic Inventory, which is a sort of a psychological battery that the courts are relying on.
Do you employ Dr. Griffith, Mr. Shader?
Yes, we do.
Don't you think you should be employing a real expert in this illness rather than a self-described non-expert?
I would like the opportunity to send to the committee Dr. Griffith's credentials. Well, I don't agree that he is not an expert in this area.
Is he a skeptic of mental illness?
I don't believe so.
then how do you explain the number of denials that you've had and claims for PTSD?
PTSD is a very difficult phenomenon to diagnose and prescribe treatment for, and it isn't, even when it exists, it doesn't always prohibit or inhibit somebody from holding gainful employment, which is really what...
Well, this subcommittee, if it hasn't already, will ask AIG for its records on the rate of denials of application for claims for PTSD. We will also ask both CNA and AIG for information and internal documents and memos and emails relating to the relationship between your claim denials and your profits. So you'll be getting a formal letter from the committee. I just want to let you know right now that will be coming. The chair recognizes the gentleman from Ohio, Mr. Jordan.
Thank you, Mr. Chairman. Mr. Moore, what percentage of the claims that you receive are PTSD claims? Or Mr. Shader? I'm just curious.
We don't have precise numbers on that because we don't track that as a characteristic. I would estimate it about 20%.
Same percent that Mr.
Cases,
Pitts
yes.
said the type of cases he brings. So is that consistent with you too, Mr. Fay?
I'm sorry. Go ahead.
I'm sorry, I really do not know what the percentage is. I just know that on those very few cases that went to administrative law judges, only 2 of them were PTSD, and we prevailed in one, and the claimant prevailed in one.
Okay. Let me change gears here. One of the questions I have from you, it's been alleged that companies are denying claims for fear that they will not be reimbursed under the War Hazards Compensation Act. Is there any truth to that? Have you had any where the government hasn't reimbursed you for a war-related injury?
We've submitted about $42 million of claims that we had paid before certification under the War Hazards Compensation Act, and have to this date only received $3 million.
Wow. Has that impacted your decision in how you've handled the cases that claims come in front of you? Mr. Fay.
The War Hazards Act people are actually a small group. We're talking 4 or 5 people in Ohio. And their job is basically to protect the taxpayer from bad War Hazards Act claims. So they're sort of skeptics. So if there's a gray area, they're going to deny the claim, or there's an impetus to, which makes sense. That's their job. However, PTSD, by its nature, you could say is fuzzy. So it's an assured, it's something that would make sense. If you're an insurance company, you've got this fuzzy claim and you want to get your money back, drag it out, litigate it. If you lose, there's going to be a judicial holding. This is from the war. Then you know you're going to get your money back. Then you also get to turn in your attorney's fees and get the 15%. So that's what's going on. From my point of view, that's my opinion.
Mr. Pitts, let me stick with you on an issue that I brought up earlier, and I think coincides with your testimony. You suggest employers get a signed written statement and put families on notice about DBA benefits. DynCorp has this civilian police employee assistance program. Your thoughts on that kind of program, and if that's something we should encourage, Department of Labor should encourage with contractors they're doing business with?
KBR also has the employee assistance program to some part of the war, I think, where they were paying for like 8 visits or something to a psychologist. I'm not sure if they're still doing that. I don't see so many people do it now. Okay, so that's, in some instances they were doing something like that. DynCorp, I have to say, was proactive about PTSD and some of the other things. I really think they deserve some credit for that.
Mr. Newman, can you like to comment?
Yes, sir. We started the simple employee assistance program for several reasons: to bridge the gap with the insurance carriers, because we thought the gap was bridgeable. In reality, even the request that we would make of the insurance carriers oftentimes were totally ignored. But I was discussing with a colleague actually from DynCorp, who was here earlier today, about that issue of almost a national employee assistance program or something to that effect, or encouraging the employers, not the insurance companies, of having that type of program. And we offer, or at DynCorp, I can still consider it we, we have a psychological staff that, regardless of whether it's a covered claim or what, they still provide some psychological services for post-traumatic stress. And I do want to comment on post-traumatic stress. I deter that it's fuzzy. It's pretty clear when you actually see it.
Mr. Smith,
Can I clarify that on the fuzzy? What I mean is legally fuzzy in the sense that the insurance company can always say, well, it's personal problems. How do we know it comes from the war? And they are afraid that the war hazards people are going to see it as fuzzy and deny their claim. So it hedges their bet tremendously to just go ahead and litigate all this stuff out, which is bad on the country. It increased costs. It's wrong. But that's why structurally it's happening.
Yes, sir. I want to apologize to Mr. Pitts for referring to his comment of fuzzy. I was more referring to the comments of malingering, et cetera.
Just the lawyers are getting nervous. I knew it. Thank you, Mr. Chairman.
I thank the gentleman. Chair recognizes Mr. Cummings. Maybe speak for 5 minutes.
Mr. Chairman, I don't think I'm going to use all my time. I just want to say to you, Mr. Newman, Mr. Smith, Mr. Woodson, I want to thank you for your service. Sometimes I think people can get confused and not do everything that they're supposed to do for people who give so much. And we got to straighten out this mess. You heard Mr. Seth Harris say that we got major problems and they need to be corrected. And you even heard some of these witnesses imply, at least. I know how you feel, Mr. Pitts, but some of my other witnesses too, that we got to straighten this out. And we're going to do that. And because we can be in a situation where you continue to suffer, get no real relief, and the beat goes on, the AIGs of the world continue to get their bonuses and go on their junkets. And the CNAs, no matter what the general may say, goes on doing their thing, but then you're left to suffer. We can do better than that. We're a better country than that. Particularly when you consider the fact that the hard-earned dollars of our constituents are paying into these insurance companies and they cannot lose. You understand that? The way this thing is structured, they can't lose. Which makes it almost criminal. The idea that when they get our money, that's number one, then they're supposed to take care of you, and if they don't, then they don't. Then you suffer, and they get rich. Boy, what a game. What a game. And so some kind of way we've got to turn this around. And so we have a very committed chairman of our full committee, Mr. Towns. We have a very, very dedicated and hardworking and just a strong chairman of this committee, subcommittee, Mr. Kucinich, and I know we'll have our rankings hopefully joining in, because this is an American problem. This is not a Republican and Democrat. This is American. This is what you. I mean, if you're talking about being patriotic, we take care. This country takes care of its own. We have become the great country that we are because of our moral authority. Not so much the military authority. It may back up the moral, but it is the moral authority. And one part of moral authority is that you take care of your own, period. And so I want to thank you for your testimony, and Mr. Chairman, I'll yield back on that.
I thank the gentleman. The chair recognizes the gentlelady.
Mr. Chairman, I just have to read part of my opening statement because I think it goes right to the reason why we've had this hearing. In 2008, there were 200,000 civilian contractors in Iraq and Afghanistan, and there were more civilian contractors than there were U.S. troops in both combat theaters combined. And the contractors' presence in these combat zones go primarily under the radar, and very little is reported on the number of injuries they sustain due to the service they provide in aiding the federal government in its mission. And as of June of 2008, more than 1,350 contractors have died in Iraq and Afghanistan, and there was another 29,000 injured, and more than 8,300 of them were serious permanent injuries. And so as the number of Defense-Based Act claims rise for compensation due to injury or death of a contractor, the payments on the amount of compensation benefits paid per claim have dropped to their lowest level since 2003. And I'm wondering how this can be with the high levels of injuries that are being sustained by contractors themselves. And Mr. Smith, I don't understand ignored. You know, how could they ignore the claim? Can you explain what you mean by ignored?
Yes, ma'am. The Department of Labor would make a finding in an informal hearing. That's the first step in the process of litigation. And I'm sorry, ma'am, I don't know any way to put it, they absolutely ignore the Department of Labor finding. The
Department of Labor then?
Yes, ma'am.
Secretary?
Yes, ma'am. In my case,
yeah.
In my case,
I want you to know, Secretary Hilda Solis said there's a new sheriff in town.
Yes, ma'am, and I understand that, and I'm proud to hear that, and I thank this committee for stepping up and taking the ball. But in my case, that is exactly what's happened, and in my opening statement, I have the proof in the documentation.
Yes, well, I hope that you will share those papers and your documentation with Mr. Schrader.
Yes, ma'am.
And Mr. Moore.
I will provide that to this committee, who can then...
Thank you, as soon as possible. And
within 24 hours, ma'am.
Thank you.
Yes, ma'am.
With that, I'll defer the rest of my time, Mr. Chairman, to you.
I thank the gentlelady. The committee submitted for the record information that AIG had a net earned premium from the government of $1.3 trillion, 2002 to 2000, strike that, billion, $1.3 billion. That's $1.3 billion in net earned premium from 2002 to 2007, and underwriting gains of $500 million for a 38% gain. Now, Mr. Woodson, you lost a leg, and you lost almost all of your eyesight.
I lost the sight of my...
Could you put that, give him the microphone?
I lost the sight of my left eye, 3/4 of my right, and I lost my left leg. At the present time, I'm using a magnifier to try to read. AIG will not even pay for the glasses that the doctor has ordered back in April.
Net earned premium, $1.3 billion, underwriting gains, $500 million, 38% gain. Mr. Moore, when you hear this, do you feel any sense of regret or concern about what Mr. Woodson has gone through? How does this make you feel?
Mr. Chairman, there's no doubt when you hear something like this and you see something like that. And
Please speak into the mic so we can hear you.
Mr. Chairman, there's no doubt that when you hear something like this, and with any of these gentlemen and what they've done and served the country, that you do have a feeling towards it. My job is to make sure that we're doing everything we possibly should do and that we are obligated to do under the current regulations and the laws to provide the right care for these individuals, and that's what Mr. Shader...
You're telling Mr. Woodson that you did everything you could for him. Is that what you're telling him? Is that your testimony?
No, my testimony, I haven't personally done everything I can for him. I don't know. I'm just saying
that your company, AIG, has done everything it could.
You wanna,
is that your testimony?
Mr. Shader, you want to answer that? Yes.
The answer is yes. It is everything that we could have done. And just as an example, and I don't know where the communication is failing, but on the glasses prescription that was written and submitted to us on 4/28/09, it was approved the same day.
They have never paid for it.
Mr.
They still
Woodson?
have the glasses.
Mr. Woodson, you say they never paid for it?
Never have paid for it.
See, this is the reason why we brought these witnesses here. These are people who are part of the hundreds of thousands of contractors who are insured through a variety of companies with the government making sure that you get money to pay claims. And when you don't pay claims, what happens when insurance companies don't pay claims? Typically, the profits are higher. That's our concern here. Our concern as a committee is that Mr. Newman, who lost a leg, Mr. Smith, who suffers from PTSD, Mr. Woodson, who lost his eyesight, most of it, and has a prosthetic leg, that each and every one of them represents not just the three of them, but they stand for many more who served America as private contractors, who were injured and sometimes killed, who cannot get any justice because, look, if you're the insurance company, you deny a claim, they're already at a disadvantage to fight you. If you defer paying a claim, you could drag it out. How long did it take you, Mr. Newman, to get your leg?
500.
Would you go speak into the mic? How long to get your new prosthetic leg?
I'm sorry, sir. The newest one, it took over 550 days.
560 days. Is that is that acceptable? It can't be acceptable. So the committee's going to go further into this. I just want you to know we're going to have to move on to votes here. I'm going to, every person here who is asked to testify will be continuing to stay in touch with the committee and the committee with you. You'll all be given a chance to get your testimony into the record of this hearing. But we're going to pursue this more because if these three gentlemen, with the grievous injuries that they've suffered, can come here in front of a congressional committee and take an oath to their testimony, and then we find out that there's this disconnect between payment of their claims and satisfying them so their lives can be made whole. Because let me just tell you something. You gentlemen, General Fay, Mr. Moore, Mr. Shader, you're going to walk out of here with your two natural legs. You're going to walk out of here not needing assistance to see where you're going. You're going to go home, and you won't be troubled by flashbacks about combat. You don't have to contend with what these gentlemen have had to contend with and what many others who serve the country as contractors have had to contend with. So that's why we're holding these hearings. And this isn't about you personally, but you stand for institutions that we have to find a way to make them more responsive. I want to, the gentlelady's time has expired, and I'm going to just wrap this committee meeting up, putting into the record that CNA's net earned premiums from 2002 to 2007 were $110,722,000. Their underwriting claims were $58 million. Their percent of gain was 53%. We have others that are involved too. I want to put into the record this memorandum from staff. It's an exchange regarding the source of a majority memo that was referenced by Mr. Fay's testimony. This committee operates under the rules of the House, and the rules are pretty strict with respect to the gathering of information and the production of records. Major General Fay, a witness for CNA, made explicit reference to the majority staff's memorandum to members, which is a public document prepared for subcommittee members in advance of a hearing. Chairman Kucinich, and this is prepared by the staff here for this just now, Chairman Kucinich asked General Fay how he obtained a copy of the committee memo. General Fay responded that a member of his legislative staff provided it to him. She and a colleague were identified and approached the witness table. Heather Davis was sworn in. When asked how she obtained the majority's memorandum, Ms. Davis said that General Fay may have been in error and that the source to him of the memo was either herself or her male colleague. She said that she obtained the memo from committee staff. She was asked if it was a Democratic committee staff member who provided the memo. The male colleague responded that it was not a Democratic committee staff member who gave the committee memo to CNA. This subcommittee, well, this is essentially an internal matter. It was made external because of the fact that you, General Fay, received information that rightfully should not have been in your possession. We will investigate that further, and our attorneys will be in touch with you and your staff regarding this matter. I also want to say that in response, and by the way, I want the majority staff to know that I showed Mr. Jordan these remarks that I'm about to read into the record. In response to the comment of the ranking member, I would like to correct the record. The majority has extended the customary accommodations to the minority, including the subject of the hearing, a detailed briefing memo on the subject matter, the contact information of all witnesses, and the right to invite a witness. If the minority had difficulty preparing its members for this hearing in spite of this considerable assistance, then we look forward to working with you to try to find out how we can make this work for you, because we value your cooperation and we want to make sure that, that you have every opportunity to prepare for these hearings in a way that you feel is important for those that you serve, because I value greatly the work of staff on both sides. I want to thank each and every witness here. As difficult as it was for CNA and for AIG to be here, we do need your help in trying to straighten this out. And this is not simply a private sector matter. I just spent the last 6 years trying to get the Defense Finance Administration away from a privatization program that Lockheed Martin had that was similarly denying people their claims for whatever reason. So this is something that we see some systemic problems. In our conversations that were detailed with Lockheed Martin, we found that the best solution for them was to simply give the business back to the government, which I think they were glad to do. In your case, because they weren't making money on it, at least they weren't making as much money as you are. I want to thank Mr. Newman again, and Mr. Smith and Mr. Woodson for your service to the country. Your presence here represents a lot of people who were private contractors who served. And I think that everyone here, whatever their position on this dais and whatever their position in the audience, appreciates that you served, appreciates the price that you paid. And I think everybody's going to take a renewed interest, I would hope, that a renewed interest is going to be taken in your situation, but then to expand to the larger question. Mr. Pitts, thank you for your service as well. Again, I want to thank the witnesses. We will be in touch with all of you. This is the domestic...
Would you yield for a second?
I will yield to the gentlelady, of course.
The reason why I read my opening statement, some paragraphs from there, because I stated some of the numbers, and so we will submit that too to go along with the report. So we'll have the numbers.
The record of this hearing will remain open for 5 legislative days.
Great.
And the gentlelady's submission will be valued and gratefully received. And I just want to make sure that I submitted this for the record from this calculation of profits that's from CNA.
Thank you. I yield back.
I thank the gentlelady. I also thank her for her willingness to work with us in crafting a legislative solution. The representative from the Department of Labor said it's really up to us, and we do have a responsibility here to look at this legislatively, and we're going to. This is the Domestic Policy Subcommittee. I'm Dennis Kucinich, chairman of the subcommittee. It's a subcommittee of government oversight and reform. This has been a hearing that has dealt with the issues of claims not being paid, the reasons why that could happen, and what could be done in the future to rectify that. I want to once again thank all the witnesses for their appearance. We'll continue to be in touch with you. This committee stands adjourned. Thank you.